Corbier Laval, and I'm a Anishinaabe Nation and a member of the Wikwemikong unceded Indian Reserve on Manitoulin Island in Ontario. Thank you, Commissioners, for this opportunity to share with you information about the tragic disappearances and murders of Aboriginal women and girls in British Columbia, Canada. Two national organizations are represented here: the Native Women's Association of Canada, of which I am the president, and we're also known as NWAC, and the Canadian Feminist Alliance for International Action, or FAFIA. I would like to introduce our delegation. I have Sharon McIver and Sheila Day. Sheila's behind here. Leaders with FAFIA, two staff members of NWAC, Claudette Dumont-Smith, member of the Kitigan CB, Algonquin First Nation, and Irene Goodwin, who's Ojibwe from Northern Ontario. It's right up there. Laurie Ojig of Kitigan CB is at the table, and whose daughter has been missing since 2008, who is also an advocate for family members of missing and murdered Aboriginal women and girls. Dr. Gwen Brodsky, who's our legal advisor to NWAC, Carolyn Bettinger Lopez, Rachel Osendorp, and Amanda Darlington, right behind, and they're from the University of Miami School of Law Human Rights Clinic. This is the first time the Inter-American Commission has considered the issues surrounding missing and murdered Aboriginal women and girls in British Columbia, Canada. I will speak on the situation of missing and murdered Aboriginal women and girls in British Columbia and the failed efforts to address this issue so far. You will then hear from my colleague Sharon McIver, who will explain the social and historical context of this issue. There are many community organizations and networks of family members of missing and murdered Aboriginal women and girls who are politically active and working tirelessly to bring attention to this issue by holding vigils, marches, and teach-ins to raise awareness of the violence, and NWAC is honored to be part of this movement. NWAC has documented over 600 disappearances and murders of Aboriginal women and girls over the last 30 years in Canada. Translated to the general population, this would be over 19,000 women, enough to populate a small city. British Columbia has the highest number of missing and murdered Aboriginal women and girls in Canada. This province accounts for 160 of the cases in our database, NWAC's database, or 27% of the total for all of Canada. Of the 160 cases in British Columbia, 63% are murder cases, 24% are cases of missing women and girls, 49% of the murder cases remain unsolved. Among the highest rate of unsolved cases in Canada, 59% are women and girls under 31 years of age. The majority of the missing and murdered women are mothers. Almost half of those charged with crimes against the women were strangers or acquaintances, with only 10% of the cases involving an intimate partner or family member. The killings in British Columbia often occur in clusters. Starting in the early 1990s, more than 60 women went missing from downtown Eastside, Vancouver, which is Canada's poorest neighborhood. Most of the missing women were poor, some were involved in prostitution, some were drug addicted, and many were Aboriginal women. When friends and family members reported to police that a daughter or sister was missing, they were met with dismissal, refusal to take reports seriously, and even as the numbers increased, a disbelief that there was any pattern to the disappearances or that women in downtown Eastside area were in any particular danger. Police assumed that the women were living high-risk lifestyles and were likely to move around. Police investigation into the disappearances finally began in the late 1990s and resulted in the arrest in 2002 of the serial killer Robert William Pickton. Pickton was charged with first-degree murder in the deaths of 26 women in British Columbia and convicted of second-degree murder on 6 counts. A disproportionate number of Pickton's victims were Aboriginal. Many believed that Pickton could have been arrested and prosecuted much earlier, and this would have prevented a number of the deaths and much grief to the families and children. According to a Vancouver police report, the Pickton investigation was plagued by a lack of resources, training, leadership, and poor continuity of staffing, and multi-jurisdictional challenges. The Vancouver Police Department and the Royal Canadian Mounted Police, who were both responsible, blame each other for the failures. Another cluster of killings has occurred along a highway in northern British Columbia, now known as the Highway of Tears, because of the disappearances and murders of Aboriginal women and girls. According to an official police count, 18 women and girls, most of them Aboriginal, have gone missing in the vicinity of the Highway of Tears. Many claim the list could be much longer. The failure of police investigation in relation to murders and disappearances of Aboriginal women and girls in British Columbia is not surprising, as sexism and racism appear to be embedded in the practices and operating assumptions of the system. Recent media stories have revealed pervasive sexual and racial harassment inside the RCMP. Aboriginal women and girls report sexual and physical abuse by police and police guards, and this abuse is overlooked and apparently condoned. For example, in recent years, at least 20 young Aboriginal girls who were between the ages of 12 and 16 accused Judge David Ramsey and other criminal justice officials in Prince George, BC, of sexual and physical abuse. Ultimately, the judge pled guilty to 5 counts of brutal sexual and physical violence against Aboriginal girls, whose cases he presided over in youth criminal and family courts. The systemic nature of this problem is demonstrated by the fact that the judge was allowed to remain on the bench for 3 years after the police investigation had begun, and the abuse continued during this time. Among the criminal justice officials accused of sexually exploiting teenage Aboriginal girls in Prince George were 9 police officers, a lawyer, and a prison guard. None of them was prosecuted. The most significant response to the disappearances and murders is the Government of British Columbia's establishment of the Missing Women Commission of Inquiry, which I will refer to as the BC Inquiry. This is an inquiry into the facts, police investigations, and official decisions involved in the Pickton serial killer case. The BC Inquiry is due to report by June 30th of this year, 2012. Although Aboriginal women were disproportionately represented among Pickton's victims, the BC Inquiry will not have the benefit of relevant evidence and analysis regarding systemic violence against Aboriginal women. Nor will there be rigorous cross-examination of police and government witnesses about the systemic failures of the justice system to protect Aboriginal women and girls from violence. Initially, NWAC and 12 other knowledgeable community groups were granted standing to participate in the BC Inquiry. However, in a decision that is unprecedented in Canada, the Government of British Columbia refused to provide funding for the group's legal counsel to facilitate their meaningful participation, our participation. The effect of the government's refusal was to shut NWAC out of the BC inquiry, along with most of the groups to whom standing was granted. Now, 25 publicly funded lawyers represent police and government at the inquiry. There are no publicly funded lawyers representing any Aboriginal parties and no Aboriginal organizations participating in this inquiry. Consequently, the inquiry has no specific focus on Aboriginal women, and there is no prospect of cross-examination that seeks to shed light on the pattern of violence against Aboriginal women and the lack of effective state response to it. In short, the BC inquiry has become an unbalanced, unfair, and discriminatory process. As a result of this experience in British Columbia, NWAC has concluded that only a national inquiry specifically focused on disappearances and murders of Aboriginal women and girls can properly address this crisis and lead to a national action plan that is coordinated and strategic.
Thank you, Commissioners, for this opportunity. My name is Sharon McIver. I'm a Thompson Indian and a member of the Lower Nicola Indian Band in Merritt, British Columbia. I live and work about 3 blocks from the spot where I was born. I want to speak briefly this morning about the layers of discrimination that are the root causes of violence against Aboriginal women and girls in British Columbia and Canada. These layers include a dehumanized and degrading view of Aboriginal women introduced and fostered by settler governments and officials, the imposition through Canadian law of patriarchy and male dominance on cultures that were matriarchal or semi-matriarchal, the theft of culture, language, and family connections brought about by the forced placement of Aboriginal children in residential schools, and the sexist and racist impact of profound social and economic disadvantage of Aboriginal women and girls. Colonialism has had a different impact on Aboriginal women than on Aboriginal men. In addition to the theft of lands, resources, culture, traditions, and languages experienced by all Aboriginal peoples, colonial laws and policies targeted the power of Aboriginal women as family anchors, caregivers, nurturers, decision-makers, and equal members of their communities. Before colonization, Aboriginal women commanded the highest respect in their communities as the givers of life and keepers of the traditions, practices, and customs of the nation. Many, if not most, Aboriginal cultures in Canada were matriarchal or semi-matriarchal. Patriarchy and male dominance were introduced to Aboriginal societies through missionaries and subsequently made law through the Indian Act. Colonizers transformed Aboriginal women from equal partners in their cultures into squaws. The squaw is a degraded and dehumanized figure, the female counterpart to the Indian male savage. She has no human face. She is lustful, immoral, unfeeling, and dirty. This grotesque dehumanization and sexualization of Aboriginal women has rendered them vulnerable to gross physical, psychological, and sexual violence. When the Manitoba Justice Inquiry inquired into the 1971 murder of Helen Betty Osborne, it recognized that the intersection of racism and sexism have contributed to the view that Aboriginal women are sexually available and that violence towards them is justified. Helen Betty Osborne was a 19-year-old student when she was abducted by 4 white men in La Paz, Manitoba, driven out of town, sexually assaulted, and murdered by being stabbed more than 50 times with a screwdriver. The Manitoba Justice Inquiry said, her attackers seemed to be operating on the assumption that Aboriginal women were promiscuous and open to enticement through alcohol and violence. It is evident that the men who abducted Osborne believed that young Aboriginal women were objects with no human value beyond sexual gratification. Although this murder occurred 50 years ago, the view of Aboriginal women as squaw is still alive and well in Canada. The theft of equality from Aboriginal women was accomplished partly through the Indian Act. Until recently, the Indian Act defined an Indian as a male Indian, his wife, or his child, reflecting the practice of colonial patriarchy. On marriage, Indian women became property of their husbands. Indian women could not transmit Indian status to their children. Indian women who married non-Indians were stripped of their status. Conversely, however, Indian men who married non-Indians transmitted their status to their wives, and their non-Indian wives were considered Indians, while the Indian women who married were considered non-Indians. Both Jeanette Corbier-Laval and myself have challenged the sex discrimination in the Indian Act in Canadian courts. Jeanette under the Canadian Bill of Rights in the early 70s, and me under the Equality Guarantee of the Constitution starting in 1987. We are proud of the changes achieved because of these challenges. But the sex discrimination is not yet gone from the Indian Act, and we know that the long-standing legislated treatment of Aboriginal as non-persons, the property of men, is one of the root causes of violence against Aboriginal women and girls that is widespread, even ordinary, in British Columbia and Canada still today. From 1876 onward, the Indian Act allowed the Minister of Indian Affairs to control education for Indians to further the goal of assimilation. Indian children were forcibly removed from their families and placed in residential school, which were mostly run by the churches. Children were rounded up by the RCMP, and parents could be imprisoned and were imprisoned if they refused to let their children go. Parents were not allowed to visit. The children were forbidden to speak their own language. The children did not learn how to parent and forgot how to live in a family. The family unit was broken. Besides the starvation and disease experienced in residential schools, physical, mental, and sexual abuse was rampant. Generations of Aboriginal boys and girls grew up with male teachers and priests who were abusers, and they were their role models and authority figures. Canada recently acknowledged the devastating effects on Aboriginal people of the residential school policy and apologized. But among the ongoing legacy of the residential school are the dismantling of the Aboriginal women's respected role in the community, the high rate of sexual abuse and violence that Aboriginal women and girls experience now in their communities as a result of the intergenerational devastation in family relationships. Many Aboriginal people in Canada are living in third world conditions without clean drinking water and in crowded, unheated housing. Aboriginal women in Canada experience high rates of poverty, lower educational attainment, lower earning, higher unemployment, much higher rates of criminalization and incarceration, and poorer health than their non-Aboriginal counterparts. They are also much more likely to have their children taken away by welfare authorities. Aboriginal women and girls who are poor are coerced into activities or situations that increase their vulnerability to violence, such as hitchhiking, prostitution, gang involvement, and abusive relationships. International treaty bodies that have reviewed Canada's compliance with its international human rights obligations over the last decade have consistently urged Canada to 1. Address on an urgent basis the extreme violence against Aboriginal women and girls and the disappearances and murders, and 2. To develop a strategic plan to deal with their social and economic disadvantage. Canada's fulfillment of its obligations to ensure that the criminal justice system responds to and addresses effectively the disappearances and murders of Aboriginal women and girls is of utmost concern to us. However, just as important and necessary to ending the disappearances and murders is Canada's fulfillment of its obligation to address and dismantle the extreme inequality and the social and economic disadvantages of Aboriginal women and girls. The disappearance and murders which we are here to talk about are caused by colonialism, racism, and sexism. The extreme violence against Aboriginal women and girls is not accidental, and though many of the perpetrators are private actors, the violence is nonetheless caused by and exacerbated by centuries of discriminatory state action. It is our view that British Columbia and Canada's obligation to prevent and remedy violence against Aboriginal women and girls must be about dismantling the discrimination and its effects, Measures of prevention and remedy must be designed to and be able to subvert the patterns of structural subordination. We believe that Aboriginal women and girls now need assistance from the Inter-American Commission of Human Rights and from United Nations expert bodies. Governments in British Columbia and Canada must take this human rights crisis seriously and to act strategically, concertedly, and in good faith to address the disappearances and murders. So far, we are met with only piecemeal measures and failures like the BC inquiry. We call upon the Government of Canada to take the following steps. First, initiate a national inquiry into the disappearances and murders of Aboriginal women and girls in British Columbia and Canada that must address A, the discriminatory failure of the criminal justice system to protect Aboriginal women and girls, B, the lack of effective independent accountability mechanisms for the criminal justice system, C, the lack of effective state action to address the social and economic disadvantage of Aboriginal women and girls. Second, ensure the meaningful participation of Aboriginal women and their organizations in the inquiry processes. We also ask the Commission to make a visit to Canada so that you can meet with the Aboriginal women and girls, Aboriginal organizations, and our allies, and allow us to benefit from your wisdom and expertise. Thank you.
Thank you very much. Can I give the state an opportunity to respond?
Good morning. My name is Heather Watts. I'm counsel with the Department of Justice. Joining me this morning is Doug Janoff, First Secretary from the Permanent Mission of Canada to the OAS, Lynn Paré, Director General, External Relations and Gender Issues Branch, Aboriginal Affairs in Northern Development Canada, and Chief Superintendent Brenda Butterworth-Carr, Director General, National Aboriginal Policing with the Royal Canadian Mounted Police. We appreciate the opportunity to be here before the Commission today and to hear the concerns of the petitioners. We participate in this hearing today out of respect for the Inter-American Commission on Human Rights and its work in support of human rights in the Hemisphere. As this is a hearing into the situation of reports of missing and murdered Indigenous women and girls in Canada, I wish to clearly state that the Government of Canada is deeply concerned about the disturbingly high number of missing and murdered Aboriginal women and girls. Despite a number of initiatives on the part of federal, provincial, and territorial governments to address the issue, Aboriginal women and girls continue to experience violence at a much higher rate than non-Aboriginal Canadians. As you've heard from the petitioners, the challenges facing Aboriginal peoples, including Aboriginal women, are long-standing, multifaceted, and complex. There are many risk factors associated with the disproportionate level of victimization of Aboriginal peoples. These include a legacy of cultural and economic disruption through the colonization process, a history of abuse in residential schools, lower educational achievement, higher unemployment rates, alcohol, and substance abuse. Addressing the underlying issues contributing to violence experienced by Aboriginal women and girls warrants coordinated attention from all levels of government. These solutions cut across many different sectors, including the justice system, public safety, policing, gender issues, health, and Aboriginal affairs. As noted in the 2011 Speech from the Throne, the Government of Canada is committed to taking concrete action to improve prevention, law enforcement, and justice system responses to the issue of violence against women and girls and to make our communities safer. Accordingly, Canada takes very seriously the concerns outlined in the letter of request for this hearing and will attempt to address them this morning. The issues raised in the letter of request, namely the allegations of police failure to protect Aboriginal women and girls from violence and to investigate disappearances and murders promptly and thoroughly, and the need to address the disadvantaged social and economic conditions which make Aboriginal women and girls vulnerable to violence are important issues. Addressing them fully in a one-hour hearing is quite difficult, but we will attempt to provide you with an overview of some of the measures governments across Canada are taking to address these complex issues. I will deal first with the issue of missing and murdered Aboriginal women and girls. The Government of Canada's approach to the issue is focused on four broad areas. 1. The prevention of violence against Aboriginal women and girls. 2. Improving investigations and prosecution by providing additional tools for law enforcement. 3. Enhancing victim services and increasing support for the families of Aboriginal women and girls who may go missing or be murdered. And 4. Working in partnership with the provinces and territories, Aboriginal people, and other stakeholders. Preventing Aboriginal women and girls from becoming victims of violence is central to dealing with the issue. On October 29, 2010, the Government of Canada announced an investment of $10 million over 2 years to take concrete action on missing and murdered Aboriginal women, which is a multi-tiered approach to provide new tools for law enforcement, improve the justice system, enhance victim services, and support community programs to help prevent these troubling acts from occurring in the first place, and to bring those responsible to justice. Funding from this announcement is being used by the Department of Public Safety to support the development of community safety plans by Aboriginal communities to reduce violence and improve the safety of Aboriginal women within their communities. Aboriginal and community groups who work in the area of violence prevention and victim services are eligible to receive funding to support the development of school-based and community programs that aim to reduce the vulnerability to violence of high-risk Aboriginal women and girls by promoting resilience and alternatives. Aboriginal organizations can also apply for funding to support the development or distribution of awareness materials and activities that contribute to breaking intergenerational cycles of violence and abuse in Aboriginal communities that result in Aboriginal women and children facing higher risks of violence. The Department of Justice is also investing in the development of a national compendium of best practices in the areas of violence reduction, Aboriginal community development, victim services, and law enforcement to help Aboriginal communities and groups improve the safety of Aboriginal women across the country. In February of last year, Status of Women Canada approved funding to the Native Women's Association of Canada for a project entitled Evidence to Action 2. The goal of this 36-month project is to reduce the levels of violence experienced by Aboriginal women and girls in communities across Canada. Building on previous work, the project will work to strengthen the ability of communities, governments, educators, and service providers to respond to issues that relate to the root causes of violence against Aboriginal women and girls. This will be achieved by education, developing community-based resources, and engaging communities, emphasizing awareness, prevention, and responsiveness. The Government of Canada and the provincial and territorial governments are working together and in consultation with Aboriginal people and organizations such as the Native Women's Association of Canada to improve the police response to missing and murdered Aboriginal women and girls. Canada's National Police Service, the RCMP, is working with other Canadian police services, provincial and territorial governments, Aboriginal organizations, and the public to investigate and resolve cases of missing or murdered women. A number of task forces and projects have been established in areas of the country where these disappearances and crimes are clustered. For example, in 2001, the RCMP established Project Even-Handed with the Vancouver Police Department in order to enhance investigations of missing or murdered women. A similar project called CARE was begun in Edmonton in 2003. In 2006, Project EPANA created a dedicated team of investigators to continue to review files in the North District and Central Region of British Columbia, including incidents along Highway 16, which you've heard about this morning, sometimes referred to as the Highway of Tears. The RCMP has dedicated personnel and resources to investigate and analyze files regarding missing and murdered women. As a result of the RCMP's work, several cases have been resolved or advanced. For example, in mid-October 2011, a 21-year-old man from Prince George, British Columbia, was charged with 4 counts of murder, 3 of whom were Aboriginal women. The RCMP National Aboriginal Policing Services have a member dedicated to liaise with Aboriginal organizations, including the Native Women's Association of Canada. This partnership has led to the development of a community education toolkit entitled Navigating the Missing Persons Process to assist family and friends of missing persons. More recently, in December of 2011, the RCMP and the Assembly of First Nations signed a joint agreement that will see the two organizations work collaboratively on issues related to missing and murdered Aboriginal persons. Funding from the October 2010 announcement is also being used to improve tools for police investigating missing persons cases, including missing Aboriginal women and girls. The RCMP has established the National Centre for Missing Persons and Unidentified Remains, which will ultimately support and improve the investigation of missing persons cases across Canada. The Centre has employed a dedicated, experienced Aboriginal police officer from National Aboriginal Police Services to ensure a focus on the specific issue of missing Aboriginal women. The Canadian Police Information Centre has implemented enhancements to their system, which, when operational next year, will capture additional data to feed a national database for missing persons and unidentified remains. Also, a national website for missing persons and unidentified remains will be launched this year and will allow for members of the public to provide tips on specific cases. In addition to the prevention and investigation of cases that I've discussed already, we recognize the importance of supporting families of missing or murdered Aboriginal women. In Canada, provincial and territorial governments provide victim services. The federal government works closely with these governments to increase their capacity to support Aboriginal victims of crime, as well as the families of missing and murdered Aboriginal women. Building on existing provincial and territorial efforts, Canada announced federal funding in 2010 to help the provinces adapt or develop culturally appropriate victim services for Aboriginal peoples. Aboriginal community groups can also apply for funding to address the unique needs of the families of missing and murdered Aboriginal women at the community level. Through these and other initiatives, the Government of Canada has made significant investments to address the issue of missing and murdered Aboriginal women and girls. Given the recent nature of these funding announcements, it will take time before we can accurately measure the results from these initiatives. In addition to our work with Aboriginal groups and other stakeholders, the federal government continues to work in partnership with the provinces and territories to coordinate our response to the issue. In January of this year, the federal provincial territorial ministers responsible for justice released the Missing Women Working Group's final report. Ministers asked the working group to bring forward an implementation plan and reiterated their commitment to continue to coordinate efforts. The provinces have also undertaken their own initiatives. In 2006, the province of Saskatchewan created a provincial partnership committee on missing persons that is led by government officials and has members from Aboriginal, police, and non-government organizations. The committee has published a checklist for families on a public website and is working to implement a missing person protocol, which sets out standards for the police to ensure that all cases are responded to in a consistent manner and all avenues of investigation are contemplated. Full implementation is expected this year. In June 2011, with financial support from the federal government, the provincial government of British Columbia the Native Women's Association of Canada co-hosted the Collaboration to End Violence National Aboriginal Women's Forum. The forum explored the underlying issues related to violence and missing and murdered Aboriginal women in British Columbia. More than 250 participants from all provinces and territories in Canada attended the forum, with participants including representatives of provincial and territorial government departments, national Aboriginal organizations, and First Nation, Métis, and Inuit communities and community-based organizations. As you've heard from the petitioners, in September of 2010, the government of British Columbia identified the need for the Missing Women Commission of Inquiry, because it recognized that there are lessons to be learned from the investigation and circumstances surrounding the disappearance of women from Vancouver's downtown east side between 1997 and 2002. The purpose of an inquiry is for the Commissioner to establish facts and determine potential causes of events and then make recommendations to government based on the findings. The government amended the Commission's terms of reference to include a study commission to make the process less formal and more inclusive. The Commission of Inquiry is an independent, quasi-judicial body, and because it is not concluded, we are not in a position to comment on the outcomes of the Commission. The Commissioner's report to the Attorney General of British Columbia is due June 30th of this year. The Government of Canada is participating and fully cooperating with the inquiry and is voluntarily providing relevant documents in its possession. The Government of Canada looks forward to receiving recommendations in the final report. I will now turn things over to my colleague Lynn Paré.
Good morning. Canada recognized that violence against Aboriginal women and girls is a very serious issue, and as mentioned by my colleague, that Aboriginal women in Canada experience numerous challenges that render them more vulnerable to exploitation and violence. While progress is being made on many fronts, socioeconomic gaps persist. The Community Wellbeing Index measures the state of employment, education, income, and housing in a community. Between 1981 and 2006, while there was an increase in the well-being of Aboriginal communities, these increases did not keep pace with the rate of increase in non-Aboriginal communities. In addition, the Aboriginal population is younger and is growing more quickly than the non-Aboriginal population. Many of the challenges facing Aboriginal people, including Aboriginal women and girls, are long-standing, multifaceted, and complex. It is only by working in partnership with provincial and territorial government, Aboriginal peoples, and other stakeholders that effective and appropriate solution can be developed. The Government of Canada is taking action to address the issue of violence against Aboriginal women. For example, the Family Violence Prevention Program provides operational funding to a network of 41 shelters in First Nations communities, as well as support for community-based prevention projects. The Government of Canada has introduced the Family Homes on Reserves and Matrimonial Interest or Rights Act, which will help address incidents of family violence against First Nations women and their children living on reserves by providing for emergency protection orders that grant temporary exclusive occupation of the family home. The First Nation Child and Family Services Program is being transitioned to an enhanced prevention-focused approach that provides funding for increased prevention activities and services which aim to support parents and keep families together. We recognize that better educational outcomes contribute to individual and community well-being, increase labor force participation, improve socioeconomic conditions, and decrease levels of violence. Aboriginal girls and boys deserve an education that encourages them to stay in school and sees them graduate with the skills they need to enter the labor market and share fully in Canada's economic opportunities. To enhance child development and school readiness for young children, the Government of Canada supports Aboriginal Head Start programming both on reserve and in urban and northern communities. In 2008, with the goal of education reform, the Government of Canada launched 2 new programs. The First Nation Student Success Program supports educators on reserve in their efforts to improve students' results. The Education Partnership Program brings together partners from the Government of Canada, First Nations regional organizations, and Provincial Ministry of Education to improve the success of First Nation elementary and secondary students. In 2011, the National Panel on First Nation Elementary and Secondary Education was appointed to lead an engagement process with First Nation leaders, parents, students, elders, teachers, and others to provide input on how to enhance the education system and outcomes of First Nation students. Last February, the panel tabled its report. The Government of Canada will now review the panel's recommendation and determine a course of action. The Government of Canada is also committed to improve Inuit access to education. Since 2009, the government has been working with Inuit education stakeholders, including provinces, territories, and Inuit organizations, to develop a national Inuit education strategy. In 2011, the partners released the strategy, First Canadian, Canadian First. Each year, the Government of Canada also provides funding to help First Nation and Inuit students cover tuition and related expenses associated with post-secondary education. 70% of these students are for Aboriginal women. As part of addressing the gap in socioeconomic condition faced by Canada Aboriginal people, the Government of Canada is committed to enhance the labor market participation of Aboriginal women and men and has put in place a range of measures in support of these goals. Our flagship program is the Aboriginal Skills and Employment Training Strategy that support employment programs and services suited to the unique needs of Aboriginal people, including childcare to enable parents to participate in training. In Canada, there are federal investment of over $2 billion annually to fund health programs and services for First Nations and Inuit. In 2010, a 5-year funding commitment of $730 million was announced to renew key Aboriginal health programs that address high rates of diabetes, reduce risk for youth suicide and mental wellness, and support families with young children. Many of Canada's urban centres have large Aboriginal population. To help serve these groups, in 1997, the Government of Canada established the Urban Aboriginal Strategy. To address violence against women, the Urban Aboriginal Strategy supports various community-driven initiatives which build local capacity and provide vital community support to Aboriginal women and their children living in urban centres. The success of these efforts in partnership with Aboriginal leaders, organizations, communities, and the private sector, not to mention the critical role of the provinces and territories, will help to ensure that Canada's economic and social well-being benefits from strong and prosperous Aboriginal communities and individuals, and in addition, help ensure that Aboriginal women can live full, productive lives.
In closing, the Government of Canada is deeply concerned about the issue of missing and murdered Aboriginal women and girls, and to improving the socio-economic conditions for Aboriginal people across Canada. The reports of missing and murdered Aboriginal women have been of concern to Canadians, and the government is committed to dealing with this complex issue in an effective and collaborative manner. Our approach is organized around 4 broad areas: prevention of violence against Aboriginal women and girls, improving investigation and prosecution, enhancing victim services, and working in partnership to take concrete actions to prevent the disappearance or murder of Aboriginal women and girls and to improve our capacity to respond to these cases. The Government of Canada continues to take steps to improve the socio-economic situation of Aboriginal women and girls, which makes them vulnerable to violence. Significant investments have been made in the areas of justice, education, health, and labour market participation, and we look forward to achieving results to improve the lives of Aboriginal women and girls across Canada. Thank you very much. We will be pleased to entertain your questions.
Thank you very much to both the petitioners for the information you provided us and the state. I'm going to open the floor to my fellow commissioners to ask questions, starting with Commissioner Shelton. But I wish to say at the outset that this is an important hearing for the Commission to receive this information on what is a grave situation of very disproportionately high levels of murdered and missing Aboriginal women and girls, and particularly because the Commission has underscored the duty of the state to meaningfully do everything it can to exercise due diligence to prevent that violence, to meaningfully investigate it, to punish those who are responsible, and to ensure there's adequate reparations. And the Commission has on many occasions also underscored the multiple disadvantages which Indigenous and Aboriginal women face and the vulnerability to violence they experience as a result. And in that context, it is important for us the acknowledgement of the state that this is a grave issue demanding an appropriate state response to address these questions, as well as the very important questions which have been posed by the petitioners. I'll first turn to Commissioner Shelton, who I know will have some questions and comment.
Thank you. I'd like to thank both delegations for being here and for participating. I'd particularly like to thank the petitioners for sending your reports in advance. We ask that of NGOs for every hearing, and we almost never get it. It makes a huge difference when we're able to read the information in advance of the hearing. So thank you for doing that. I was struck in listening to, both reading the reports and particularly listening to the presentations this morning, of some striking similarities to a hearing we had yesterday about the situation of Indigenous women in Guatemala. One does not often hear Canada compared to Guatemala, and I think that is a reflection of the seriousness of this particular issue. I have a number of questions. One is, most of the information in the report that was presented seems to stop in 2008. Do you have statistics on that period to the present, 2009 to the end of 2011, on new cases of missing and disappeared women? It would be useful for us to have that updated information. Question I have about the jurisdictional divisions in regard to this issue. I know that the delegation of Canada has no one from the province here of British Columbia. We have had in other instances federal states bring someone from the provincial level. And my question is whether that is reflective of the primary jurisdiction of the federal government on issues of violence against women in the First Nations, or whether the province and local authorities are the first line in this regard. So my question is really about your federalism structure in reference to responding to this particular issue. And in regard to the whole contextual issue of this, it's, I guess, primarily a question for the petitioners. To what extent do you think many of these issues are linked to the land claims that exist in British Columbia? Does that have any relevance to the issue that you are presenting in this regard? I know in a number of circumstances where land has been titled to Indigenous communities, they have their own police forces and are able to do some policing of issues in that respect. So those would be my questions. Thank you.
Thank you, Commissioner Shelton. Commissioner Antoine?
Good morning. I would also like to thank the petitioners for bringing this matter to our attention for the first time, this very important issue, very complex issue, and also for the rich data and information just provided. I do acknowledge the efforts on the part of the state. We also got parliamentary paper, so we know it has reached the attention of Parliament. And I wanted to ask, first of all, about the issue of statistics, because when I was reading the report, I was struck by the fact that the issue was hidden for such a long time, and that they didn't even keep statistics by race and so on. And there were one or two places that did. Saskatchewan, I think, was one of the best practices, if I remember correctly. So I wanted to find out whether that sort of very basic step, whether there has been progress in that regard in order for us to get out of this secrecy and be able to identify the problem. That was one. There obviously need for more gender-sensitive policies and more race-sensitive policies, even in relation to basic police statistics. I also wanted to ask about the question of access to legal representation, which the petitioners identified. Clearly, this is not just a legal issue. This is a far more complex issue. But I didn't really hear a response from the state with regard to that. I heard about the inquiry, but I think they were asking about the whole question of being able to approach a court as a group. And I thought that was important, especially since we recognize that these rights are really rights in the collective, that with the essence of Aboriginal rights are really as a collective group. So are there any flexible, creative mechanisms to be able to recognize that in relation to these issues? So any progress on that front, which would give meaningful access to representation and to the courts. Certainly the broader contextual issues concern me, not just generally, but as a rapporteur for Afro-descendants and discrimination on race. I'm very interested in that. So when I do accept your visit to Canada, which I will, that would be an issue that I'm very much concerned about, and the whole way in which the culture of this dispowerment, the way in which Aboriginal peoples were disempowered in relation to Canada, and the way that overlays with economic rights and cultural rights, again, one of the areas I'm responsible for in the Commission. So I look forward to the visit, but I also just wanted to reiterate, because you said so much in your report, I'm really just acknowledging some of what you said in your own report, the way in which the issue is interwoven with that of the broader problem of poverty and economic and cultural deprivation, even in relation to males. So the whole connection with males in the society, which impacts on women in very negative ways. And I was pleased to hear about some economic programs, but I wanted to ask specifically in relation to these programs and programs which also speak to healing of the community, about the question of funding, and not just adequate funding, but continual funding, which is something I think was very important from the point of view of meaningful progress. There are lots of things that we can talk about, but I think that I'm really just interested in moving forward with the information and being able to work on behalf of the Commission with some of these issues, important issues that you've raised. Thank you so much.
Thank you very much, Commissioner Antoine. To add a few additional questions for the state, I'm interested in learning more about the mandate of the BC Commission of Inquiry, and whether it will consider the systemic conditions which make Aboriginal women so vulnerable to violence, and whether there is contemplated any other inquiry processes which will more expansively consider this question at a national level. And then also to also ask about the question of funding, as Commissioner Antoine has, about participation in these processes, and the question of appropriate funding to facilitate meaningful participation. And then finally, a question about accountability. The petitioners have raised a number of concerns about state actors who have failed to meet the required standard of due diligence. There have been inadequate investigations or inappropriate responses from judicial officers. We've heard of one incident of a judicial officer who was ultimately held accountable under the criminal law, but I wondered more generally whether the processes which are underway also plan to or are addressing the question of holding accountable the state actors who have failed to do all that they should have to protect Aboriginal women and children. And a final question from Commissioner Antoine.
Just a small question. You spoke about education and training, but I wanted to find out whether, as opposed to training, if you also have plans or programs to create employment. So not just to train for employment, but to actually create employment.
Thank you. Now, we know that you can't answer these questions here today. We know that. And we would welcome your response after this session with further documentation and in writing. So we appreciate that. And so what I'm going to do at this stage is to allow both the petitioners to respond as well as the state, about 4 minutes each. Thank you very much.
Thank you, Commissioners. About the question on the statistics, the Native Women's Association of Canada, in response to the revelation of the high numbers of missing and murdered women, initiated the Sisters in Spirit program with funding obtained from the Government of Canada. It was a 5-year initiative. It started in 2005, ended March 31, 2010. And in that project, they were allowed to do research, develop a database, and that's when they collected all the names of the more than 600 missing and murdered Aboriginal women. Once that initiative ended in March, we applied to get more funding to continue with that research process, and we were denied. So we were granted money through the Evidence to Action program, which does not allow for any research or advocacy. So hence all that had to stop, because that was one of the conditions of getting our funding from the Status of Women Canada. So as far as we know, no one has such a database. As mentioned, the Royal Canadian Mounted Police will be working on developing one. It's not developed yet, and I don't know if it's not Aboriginal specific like ours was. So that's the reason why, in response to your question, that's the reason why. Thank you.
On the issue of jurisdiction, it's been an ongoing problem because under our Constitution, the federal government has responsibility for the Indians and land reserved for Indians under their responsibility. So it has been an ongoing issue because policing in the province is shared between the RCMP, the Royal Canadian Mounted Police, the City Police, the Vancouver City Police, and there are various city police, and then there are on-reserve policing in some of the reserves. And the issue is not so much the policing, but the lack of coordination between them, and no one seems to have ultimate authority or ultimate jurisdiction. In our mind, the federal government is responsible, and it's their due diligence that we believe that they're neglecting to follow through with. The issue of, well, you said land claims, but it's an agreement. There are agreements between the policing agencies, the RCMP, and the local reserves. And so those can be easily managed by those agreements. Okay, I'm thinking that just the BC Commission of Inquiry, when
Commissioner Antoine, just briefly, I won't be able to respond now in a fulsome way to your question to us about the importance of legal representation in the relationship to the collective. We can follow up on that if you wish, but just for now, to thank you for that question and to say very much in issue in this BC inquiry when NWAC, the Native Women's Association of Canada, is excluded, is the question of the right of Aboriginal women and their democratically elected organizations, of whom NWAC is the national one, their right to participate in proceedings that affect their fundamental rights. And that point seems to have been missed by the BC government, whose tendency is to individualize completely its understanding of the rights at issue into an inquiry that clearly, to be thorough and effective, needs to consider the systemic dimensions of the problem.
Thank you very much, petitioners. You also have an opportunity to provide us with some additional information in response to some of the questions. Can I ask the state to respond?
So given that we don't have very much time left, I'm just going to focus my remarks around the British Columbia Missing Women Commission Inquiry. Unfortunately, representatives from British Columbia were not able to join us in person today, but they have been involved in preparing us for this hearing and have provided me with information on the commission itself. So that's the information that I will relay to you now. I won't get too much into the terms of reference for the Commission, but the mandate of the Commission is to investigate the disappearance of women from the downtown east side of Vancouver between 1997 and 2002, as I stated, as well as a decision by Crown Counsel in that province to stay charges of attempted murder against Robert Picton in 1998, as well as to look at the coordination of homicide investigations by more than one investigative agency, and I think that was highlighted by the petitioners as one of the issues in the Picton case was the number of different agencies involved in investigating. So that's the mandate of the Commission itself. As I noted in my remarks, it was originally established as a hearing commission. They've added a study commission portion, which, from what I understand, makes it more of an informal process. And as part of that study commission, the inquiry held seven community forums in northern British Columbia to provide an informal venue to receive submissions from interested members of communities regarding the investigation of missing and murdered women along Highway 16, which you've heard about today. Input from communities is meant to assist the Commission in carrying out its mandate to make general policy recommendations about investigation of these cases generally, so not strictly limited to the Picton case. As was noted, the Government of British Columbia decided not to provide funding for legal representation for the Native Women's Association of Canada. The Government of British Columbia only provides legal representation outside of the formal legal aid program in very rare circumstances, such as proceedings where an individual's liberty could be at stake under the Charter, so where the potential for imprisonment is there. Those are the cases that they normally provide legal funding for representation. They rarely provide funding for legal counsel for participants at inquiries of this kind, and they've made a decision that the funding that would be available, the priority was given to the families of the missing or murdered women themselves. So those family members do have funding for legal representation, and they were determined to be the priority group for receiving funding at the inquiry. As you've heard, there are a number of lawyers being paid for by the Government of British Columbia, for members of the RCMP, the Vancouver Police, and the Criminal Justice Branch of the Ministry of the Attorney General. The reason that those lawyers are being paid is because the Commission has the power to make findings against those individuals. So the Commission can make a finding that then could result potentially in, say, criminal charges later on. So the decision was made to provide funding for those people against whom findings can be made. Also, despite the fact that there is not formal funding for groups such as the Native Women's Association of Canada to participate, the Commission has employed several lawyers to present evidence and cross-examine witnesses during the hearing. in the interest of the public. There's one independent lawyer to present issues related to Vancouver's downtown east side, and 2 independent lawyers to present issues related to Aboriginal groups. The Commissioner himself has specifically acknowledged that this role is important in ensuring that Aboriginal people's interests are represented at the inquiry. I think that's all I will say about the inquiry. I have a lot more information, but not enough time, so thank you.
Thank you very much to both the petitioners for bringing this to our attention. We know there's far more which you could have told us today, and we didn't have the time to. And similarly for the state in responding, we know there's a lot of additional information you'd like us to have, and the Secretariat will be very happy to receive it from you soon. Thank you very much.